some people may be thinking, I'm young, I'm in my 20s, my 30s, my 40s. I don't need estate planning. I'm too young. I don't have anything to leave behind. I don't have that much. So that's a thought that a lot of people have. So we'll address that because estate planning isn't about it's about deciding who makes decisions for you when you are gone. It's not about how much money you have right now, how much money you make, or how much you own. This manual is founded on the principles of Christianity. I will share with you some foundational principles from the Bible that can guide your thinking about estate planning. So the first one is 1 Timothy 5, verse 4. And it says, but if any widow has children or grandchildren, let them first learn to show piety at home, and to repay their parents, for this is good and acceptable before God. The next one is 1 Timothy 5, verse 8. And it says, but if anyone does not provide for his own, and especially for those of his household, he has denied the faith and is worse than an unbeliever. That's important. That's really serious. If you don't take care of your family, you're worse than somebody who doesn't even believe in God. The key takeaway that I want you to get from these scriptures, is that God wants us to take care of our families. We show honor and respect to God and to our families when we plan for our future financial needs and our families. So let's do a quick audit. If I die tomorrow audit. And I know a lot of people always say, don't talk about death, that's so morbid. Why are we talking about death? But all of us are gonna die at some point. So it's best that we talk about things now so we can plan and have something in place for our family, than don't talk about it and then they have to deal with problems when we're gone. So if I die tomorrow, ask yourself, if you die tomorrow, who would control your money? Who would have access to your bank account, to your cash, to your stock accounts, to your retirement accounts? Who would control your house? If you own a house, if you rent your house, if you have rental properties, who would control those things? If you own a business, who would control your business? And who would control your bank accounts? So would you leave your family with probate, or would you leave them with peace? That's the big question we want to ask ourselves today. You want to make sure your family has instant access and they don't need permission from a bank, from a court, or from anyone else or any other entity to get access to your things that should be rightfully your own as a family member. So, will your family inherit peace, or will they inherit probate? So, what is probate? What is probate? Probate is the official court process that validates a deceased person's will and settles their estate. So even if you don't have a will, your family has to go through the probate process in order to get anything that belongs to you. So the probate process names an executor, it pays off debt and taxes, and it passes any remaining property after everybody else is paid to your family members and your heirs. So if you don't have a will, like I said, your family is still gonna have to go through the probate process. If you do have a will, they still have to go through the probate process. So we're gonna talk about how you can avoid that process, because it's a headache. So here's some dangers of the state's default probate plan. Now, more than half of Americans die without an estate plan, and almost 70% of African Americans don't have one. That's a lot. That's a big number. That's a huge percentage. So we need to be educated on this and take actionable steps that we can do in order to prepare for our family. So the default plan of probate, what it does is it freezes all your bank accounts. Any property that you might have, it freezes it up immediately from your family or anybody else accessing it upon notification of your death. So if you have a bank account and there's no family member on that bank account listed as a payable on death or a beneficiary or even a joint owner, if you just have a bank account by yourself Also, I want to mention that this process is really long. It's very long. Sometimes it lasts 1 to 2 years, but it can last longer. So I have a friend who's a lawyer, and one of her church members, before she passed, she asked her to, execute her will, to be in charge of that. So this was in 2020 that the church member passed away. 6 years later, she's still dealing with the probate process to try to close it out. She's had to pay tax, had to pay creditors, had to give money to the beneficiaries, which is in the will, because it's been a long, arduous process. So you want your family to avoid that process, going through courts, and have the money and whatever property or assets you have to themselves without having to go to somebody else and get permission. Because it's a long process, it's a headache, and who wants to deal with that? Also, I wanted to mention that the probate process is very covered. This is that there in the corner. So any asset that you might have, any debt, any creditors that are coming after, credit card payment amounts that are due still, medical debt, whatever else you might have when you die, it's gonna be public. The court is gonna know it, it's gonna be in the court record, and everybody's gonna know any family disputes, like if you have siblings or, any other family members who wanna say, well, I should have this much, or I should get the car, or I should get the house, whatever it is. If there are disputes, then the court record will have that and anybody can access that. So, we're gonna talk about how we can avoid that process. Now I mentioned you can create a will. One thing you create is a will, next thing you create is a trust. So a lot of people say that I have a will, I'm fine. My family's gonna be fine. Again, if you have a will, your family still has to go through the probate process, through the court system. So what the will is basically a letter to the probate judge. It's a letter to the judge at the courthouse saying, this is what I want each family member to have, this is where I want my stuff to go, basically. And it only takes effect after you pass away. Also, this process, like I mentioned, is slow, it's a public process, it's long, and it's very expensive. So, on the last time I meant to mention that almost, I think it was like half, 20% to half of a person's estate after they die goes towards taxes and fees and the court process. So, you don't want your family to have to deal with scraps after everybody else has gotten theirs. You want to avoid all that. We want to avoid that. So let's look at wills versus trust. We talked about that. So cost of heirs, 37%. But I think it was a little higher on the slide that I mentioned. But it can vary. So the next thing is the revocable living trust. So this is like a bucket that you pour all your assets in. And it's a legal document, and you say, this is what I want to happen when I die. You create this trust. It's different than a will, because one is active while you are still living. It's called a revocable living trust. And this is where you put everything into. You can put your 401k into there. You can put your retirement accounts, stocks, life insurance policies. You can put all that in your house. All this you can put into a trust. And when it's in the name of your trust, it's not in your name anymore. It's left to whoever has access as the trustee to your account, to your trust, to distribute it to whatever beneficiaries you leave the property and assets to. So we'll talk about it a little bit more. Again, this process is fast. Doesn't cost anything. You don't have to pay any court fees, any court filing fees, documents, taxes. You don't have to worry about the creditors coming after you, because the credit that you have, the debt that you have while you're living is in your name. But everything that you own, if you get the revocable living trust, you put everything in that trust. It's no longer in your name. It's not associated with you. So all your assets are in that trust. Yes. Yes.
So with the revocable living trust, is this what people are normally doing when they're putting their homes in the trust so that the nursing home doesn't come after their home if they have to go into their home?
Yes.
Okay.
Yes. So the trust will protect you. So I'll just mention this. I was gonna talk about later, but I'll go ahead and talk about this since we're talking about it now. But so when I created my trust, I took my house out of my name. My house is not in my name anymore. I filed a quitclaim deed to put the house in the name of my trust. So somebody comes after me, after my business, I don't have anything. Everything I So you can't find anything on record under my name, no assets, no property, because everything is in the name of my trust. So that can protect you from lawsuits, from creditors who try to come after you and after your estate when you die. So this is the good thing about the trust. Another thing, also I mentioned about the house. So when you sell the house, since it's a living trust, the money will go into the trust account that you create, the trust bank account. You still have access to it. You still own and you still manage the assets and the property that you own as the grantor or the main trustee of the account. So while you're living, you're the trustee, the main trustee, the grantor who created the trust. When you die, your secondary trustees take over and then they manage whatever you put in the trust. Yes, go ahead.
Does the house have to be paid for?
No, it doesn't have to pay for it.
Okay.
You just put the name, so when you buy the house, put in your name, if you don't have a trust. And then, once you create the trust, you have the trust name now, whatever you wanna name the trust, these, such and such, you put your name there. Most trusts are named after, they put your name in it, so, like Terica, Turner's Trust, or whatever. You can have it called whatever you want to. But the house will be in that name, not in your personal name anymore, yes.
How much you gotta pay to leave insurance for the start?
We'll talk about that in just a moment, but it can be expensive, but we'll talk about ways you can get around that, the cost, the high cost of it. So, the 4 pillars of living trust. 1, control. You maintain control of all your assets, everything you own, how it's distributed after you're gone. You don't have to worry about your family fighting over, oh, mom wanted me to have this, mom would've liked me, dad would've wanted me to get this, or this much, whatever. You don't have to worry about that, because while you're living, you say in your trust document, I want this percentage to go to this child. I want this percentage to go to this charity, or this church, or whatever. You dictate and have control over how your assets are distributed when you are gone. Other things we talked about, privacy. You avoid all court processes, you don't have to worry about that. Your family doesn't have to worry about getting access to your accounts, or going to a bank, or calling people. I mean, it's an arduous process. It can be really,
Yes.
yeah, it can be a hard process to go through while you're grieving, trying to get your deceased person's or family members' assets so that you can handle their business if you don't have access to it. So again, this protects you from disputes, creditors, lawsuits, or NGI. And then efficiency, it's easy. You don't have to worry about paying taxes on this. I won't talk about going to like the capital gains tax when you sell the house, all that kind of stuff, but you can save. If your house is in a trust, you can save on the amount of taxes you pay. If you decide for your family to sell that house instead of keep it in the family, you can save on the amount of taxes you have to pay on that house if you have it in a trust. So let's talk about how to build that trust. So in your folder, you'll see a document on the left side, in the back, called Living Trust. And these are easy to create. So I would recommend, if you don't have, let's say you don't have like a business or, rental property. If your portfolio, of assets is not very complicated or complex, that they just have a few things that you want to make sure your family has access to and have, you can create a trust online. There are online forms that you can fill out. You can type in the information as you go. It'll ask you, what about this, what about that, and that's what I did on that form. I just went to rocketwarrior.com, signed up for a 7-day free trial.
Thank you.
Yes. I typed in all the information. Now, I left most of it blank because I wanted you to see, where you can put your information, how you can put it in there. But you can go there. Make sure you're ready to put in your information if you're gonna do a 7-day free trial. Because you don't wanna wait and you have to pay years subscription, unless you wanna do that, that's fine. But that's just, a tip for you. But you can go rocketlawyer.com. And there are other sites too that you can create online trusts using their website as well. But that's the one I want you to do this way. fighting when they're gone, and they don't want a family member to deal with their trust or be their trustee. You can name a friend or a church member or somebody that you trust to be a trustee to manage and make sure that everything in your portfolio of assets is distributed how you want it to be distributed once you're gone. So, also within this trust, you can list beneficiaries, like I mentioned before, families, friends, charities, any other entities. And then the next, you wanna make sure you sign and notarize this. So, if you go to that website that I mentioned, you print off the document after you generate everything, you can print that off, take it to your bank, get it notarized.
So they accept this, if I feel all this, I do.
Yes, and you go get it notarized, they'll accept that.
We get it fast.
Yeah, we
To the bank, to the banks,
You can't do what?
notarize wills, power of attorney,
anything like this, yeah.
Oh, well, take it to the notary, take it to a courthouse,
Yeah.
and get it notarized. Or any notary public, you can go do that. So, make sure you get that, make sure you get it signed because it needs to be legally binding. You have to have it notarized.
So the people you put in here, the language for here, got signed off on stuff too?
No, not necessarily. So, like when I created my trust, my trustees weren't there. So they didn't have to be there. They didn't have to be there to sign anything. You are the main trustee because it's a living trust. So you are the main trustee. You take care and you manage everything that's in your trust while you're living. You still have control over it. You can change it. You can, put it in something else, another trust, or take it out of the trust name, put it back in your name. Whatever you want to do is yours. You manage it.
So if you're married, does the couple have to have, can they get a trust together, or is it best for each individual person to get their own trust?
Well, I think it's on case by case basis. If you want to do a trust with your spouse, you can have the trust in both your names. Or you can just do it separately. It's just up to you. And within that trust, if you do complete it, as a whole, you can just make provisions for how you want everything to be distributed. Like if somebody passes away, like I know in my trust, it mentions like, certain beneficiaries will get this and that. And if they don't, or they're not living at the time of my death, then it'll go to their heirs or, next person on. So, I would recommend though you do it by yourself because, you never know what might happen to whoever. So, yes, ma'am.
Once you finish doing this and get it notarized, where do you take it?
You take it to the courthouse and they'll give you a certificate of trust. You'll have a certificate of trust at the end of that document. And you take that to the courthouse so that they'll know when you die, don't start the probate process. You don't need a probate. She has the trust already. So, what I did was I took mine to the courthouse in the county that I live in. Gave it to them, they charged you. Yeah, of course, anytime you file paperwork, you got to pay. Yeah, I can't remember how much it was, like $50 or something. But you file that with the courthouse, so they have it on record, knowing, hey, when this person dies, we're not gonna start the probate process, we're not gonna go through all that. And,
So basically, all you doing is paying a court fee and file and notary.
right, exactly,
And you have access to all of your.
exactly.
Working at the nursing home, I see it so much where people lose everything.
Yep.
Because there was nobody to take over their things and now they have pension and nobody did any of this, so.
Right, so it's very important, because we never know what might happen.
Right.
To us or our family members, which leads us into the next thing I wanna talk about, the question. Not just you, yes.
Well, you said, you fill this out, and put whoever you want on it, right?
Mm-hmm,
Then cash, get it notarized, then cash at the courthouse.
yes. Because like, if you just have a will, let's say you already have a will.
No, you got no will, that's
Okay, well, the trust is the way to go, I promise you, the trust is the way to go, because like we talked about, your family is still gonna have to go through the probate process if you have a will. And it can take months to years, like I mentioned, my friend, she's been working with this, probate process for the deceased person for 6 years. 6 years, she's a lawyer, she had to get a lawyer, even though she is a lawyer, she had to get a lawyer to handle this stuff. And pay the lawyer, pay all the family members their portion of the distribution that they receive, pay her taxes, it's so much involved. So you can avoid all that with the trust.
Oh, it is now, you can avoid
Yes, you
all.
can avoid all that with the trust, yes. Now, like I I said, if you have complex assets, like if you own a home, if you own, a business, then you would wanna go to a lawyer, so that you can make sure and it's filed correctly. I mean, you still could do it on your own,
I
online.
got a home, it's paid for,
Yeah,
and I got cars paid for, and a little everything. paid.
yes, so you wanna make sure that's protected and your family, all that's not seized up, and it's not frozen from your family having access to it when you're gone. So, trust is the way to go.
Okay, I have to read it over.
Oh, yeah, for sure.
And then,
Adding real quick.
Go ahead.
You know, as you're talking, I'm really, thank you for just sharing. A lot of times people think a trust is only for wealthy people. It's not. Anybody can have a trust. If you have assets, you wanna make sure you have a trust. Because, you know, as Terica said, a will is good and it has its place, but that will is public knowledge. Everybody knows what you have listed in your will. A trust, nobody knows. It's blind to everybody except you and those that you've left those assets for. And so that's the important thing about having a trust. And a beautiful thing that Terica's done, she's already made it easy for you. Putting a trust together with a lawyer would cost you anywhere from $150 to $2,500. It just depends on how many assets you need to add. The last thing I'll add, and I think that's exactly where we're getting ready to go into, once you set up the trust, don't just get a document drafted, funded. It needs to have money in it for it to be living. In order for it to be a live document, it has to be funded. Now, you're probably saying, I don't wanna put no money in it. If you're getting social security or a pension or something, retitle the name of your account, because you're the sole trustee for your trust. It belongs to you. You control it.
well, I got about 4 or 5 different banks I deal with.
Yes.
And I got money in all of them. And I got what it is, CDs in 4 or 5 different banks.
And you got beneficiaries on each one of them?
Yes.
Okay. Alright, that makes a difference.
Yeah, it does make a difference, so we'll talk about that in just a moment here. So like Ms. Silver was saying, you do wanna fund it, after you create the trust, it's useless if you don't put all your assets in the name of your trust. Otherwise, it's still gonna be in your name, and your family's not gonna have access to it, so you have to transfer everything over to the name of the trust.
It got more than
It's gonna be a
that.
risk. It's gonna be a risk. If you go to a nursing home, anything you got in your name, your money is at risk. The trust keeps the risk, it eliminates the risk.
Exactly.
Because the nursing home, the first question they're gonna ask you is what kind of assets? Well, I got bank accounts, CDs, we want it.
Right, even creditors too, like we mentioned before, creditors, you know, IRS, everybody's gonna come for your money if it's in your name still, but if it's in the name of the trust, nobody knows it, you know, they can't access it. Yes,
Well,
ma'am.
yeah, I agree to, a lot of it because I invest
Yeah.
all the time.
Yeah,
Every time I look around, I'll call and check on something.
well, that's
You
great.
know, I've been a hustler all my life,
Okay,
and so, and I know what to do with mine.
yes,
And I know
yes,
how to spend it, I know how to throw it away, and I know how to save it.
yes, and you work hard, and you earn, and you put all the effort to make sure that you have while you're living, that's why you wanna protect it for your family when you're gone, and the trust is the way to go. Yes, ma'am, come back.
So like, you had your trust, and you wanna go open up an account at a new bank. Instead of putting it in your name personally, you put that account into the name of your trust.
Exactly,
And you
exactly.
still have access to it.
Exactly.
Put it into the name.
Exactly. So for instance, when I created my, trust, I went ahead and went to the bank, and I created a bank account, not in my name, in the name of the title of my trust. So I'm not, you know, on that, it's the name of my trust, but since I am the grantor and living, I am the main trustee, so I have access to it. And my trustee, my secondary trustees have access to it as well, because they're on the account also. So you can't create an account, nobody past that, no creditors or, any entities that might come after you for a lawsuit or anything like that, that's
So who's the trust? Your name and Terica, your name is grantor.
My name is, yes, grantor and trustee.
So, that was basically, man, so you grantor that eliminates you, but you're the grantor,
I'm-
you're still able to.
I'm in control of it, I manage it, yes. So I can change it, I can update it, I can move people out as my beneficiaries, I can add people in as my beneficiaries. I can, if you have a dependent child, we'll talk about this a little bit later, if you have a dependent child, or someone who you need to have taken care of when you're gone, you make sure they have someone taking care of them, and the money is distributed a certain way, you can outline that in your trust. Otherwise, the court is going to designate a conservator or, not conservator, sorry, that's another thing, a guardian for your dependent child, when you die. And you don't want that, you don't want someone else in control. You wanna be in control and say, this is who I want taking care of my child, this is how I want the money distributed, and you have control of that.
The second part to that question, so when you open that new account and it's under your will, would that be considered funding?
Yes,
the
when it's
trust
under your
to
trust,
make sure you keep
yes,
it going, cause you said you had to make sure you fund it. So
That's-
with that new account in your trust name, that's considered funding when you put money into that account, that's.
Yeah, not necessarily putting money in it. When you fund it, funding doesn't necessarily mean you putting money into the trust.
Okay, that's
So
what I'm getting.
Funding means, which we have up here, you wanna update the title and ownership of your bank account for whatever you own. So like funding means you're putting whatever you own in the bucket. Trust is the bucket, remember?
Mhm.
So when you fund it, that means you put it in the bucket. So you put your house in the bucket, the name of the trust on the house. You put your bank account in the bucket, take your name off it, create a new account, put the trust name on there. So you are not,
So
funding
funding is
funding
adding
means,
different things to the trust.
yes, yes.
Versus when a person usually a fund, they think of putting money.
No,
in
that doesn't
funds.
necessarily mean that.
So that's what.
Yeah,
I'm saying.
funding means you put everything you own in the bucket, basically. So
Yeah.
for instance, let me give you this example. Everybody knows Michael Jackson, he died in 2009. He had a trust, but he didn't fund his trust. So his family and music executives are still to this day fighting over his assets. And up to this point, his estate has paid over $100 million in fees, taxes, all that. Because he didn't fund it, so he had a trust document, but he didn't change all the names on all his assets to the name of the trust. So he didn't put that in the bucket, it wasn't in the bucket, he had a bucket, but there was nothing in the bucket. So you gotta put the house in the
Nothing in the
bucket,
bucket,
you gotta put the 401k in the bucket, put the life insurance policy, if you want to, in the bucket. So we'll talk about this in this, we'll just go ahead. So,
She got a question.
Go, oh, I'm sorry.
I was gonna say, if you're looking to go to the bank to set up, a trust account, you need to make sure that you have your trust documentation, as she has put in here, and it's notarized, as well as the EIN. To get your EIN for your trust, you can go to irs.gov, and it's free of charge. We're gonna require that for you to open it up.
Now, every bank is not required to have an EIN. So, good point that you make, but when you open up a trust account at a bank, you can use, since you are still living, and the trust is a living document, you can use your social security number as the account number on the bank account, as the EIN for the bank account. But it's still under the name of the trust, it's not yours. So, most revocable trusts, living trusts, since you're the grantor, you can use your social security number. Now, when you die, the revocable trust becomes an irrevocable trust. That means you can't change it. It's irrevocable. You can't change it. It's set in stone. The person's dead, you can't change what they put in the trust, so it's irrevocable. Then, it's important and it's necessary. So you can get EIN beforehand, like Ms. Ashley was saying, you don't have to. When you create an account, you can use your social security number. But when you die, the trust becomes irrevocable. In order to manage your money, your assets, your trustee, will have to go to their website, IRS, create an EIN, because your trust becomes an entity. It's not a person, it becomes an entity, so you have to have an EIN for that to begin. Any bank account, you have that. So, good point.
So eventually you're gonna have to get an EIN.
all this information in about this,
Yeah.
thing here you just kept talking about. All this information in here. Okay, I just have to read it over and see.
Oh, yeah, and if you would like a copy of, a PDF of what we shared here today, I can share that with you as well.
Well, I'm concerned a little bit more about this right here.
The trust?
Yeah.
Yeah. Yeah, and if you have any questions, like, I'm available. I can help you, I can talk to you, we can sit down and look over what you have. Yeah, we can go through this. I am a firm believer, you don't have to spend money when you don't have to, if you can do it yourself, like,
Well, like I said, I just wanna read
yeah,
it over.
to understand, yeah, I get it, yeah.
If all the information what you saying
Yeah.
in here, then I know what to do.
Yeah, now, what you have in the folder is a template of a trust. Now, everything I'm saying, all this, is not in there. That, you have a template of the trust, of what it looks like.
What it is, you just.
But if you want the information I'm sharing, I can share this with you at a later date, if you would like that.
Well, like I say, I read it over, and if I need it, I know I can, one of the sisters get the tape.
Okay, sounds good, you have a number two, so, yeah, so let's talk about the core real quickly, and then, we'll go ahead and start wrapping up. But, so the core will is, if you left something out of the trust, you have a core will. Now, the core will doesn't have to probate, none of that, it's part of the trust. So, let's say, you have a car, or, sentimental items that you wanna leave, furniture, jewelry, whatever you wanna leave your family. You don't necessarily put that in your trust, you don't necessarily list all those items, but in your core will, that covers anything that you didn't put in the trust, so, it's like safety net, basically. We talked about like appointed guardian, we already talked about that, you put that in your trust as well. And then, let's talk about this is very important. So, how many of you have an advanced healthcare directive? 1, 2 people. Now, this is important because we all need one. And in your packet, you have an example of one, and I think so that you can fill in the information, take it, go get it notarized, and give it to your doctor. Keep a copy for yourself. So, this is important that we listen up and know why this is important for your estate plan and your family planning. So if something happens to you, let's say, God forbid, let's pray it doesn't happen, you get ill, you get injured, get in an accident, and you're incapacitated in some way, then you can't make decisions for yourself. You can't pay your bills, you're not awake during the coma, whatever it is. You're mentally incapacitated, whatever the case is. If you cannot manage your finances, manage your health, make decisions about your health, you want to designate somebody to be able to make those decisions for you. So the advanced healthcare directive allows you to designate a person who you want to make decisions for you when you're incapacitated. So let's say you don't. You have 3 children, and all of them are at odds about what to do. You're on a life support, you're on a machine. The machine is breathing for you. And the doctor says, we don't think, she's gonna make it. You keep her on there, she might live, she might not. Everybody's at odds in your family. They don't know what to do. One person says leave her on. One person says take her off. One person says just wait and let's figure out another week or 2. Everybody's at odds. You don't want that. You don't want your family going through that when you are sick. They're already stressed out and they don't know what to do. So you can determine, this is all about planning ahead of time. You can plan and designate who is going to be your medical proxy, the person who's gonna act in your stead, as if you would, when you are incapacitated, unconscious, sick, whatever it is. So this is why this is so important. We never know what might happen to us. We need to have an advanced medical healthcare directive available and created for us. Now, there was one example. His wife suffered from dementia. She didn't have an advanced healthcare proxy, and he had to go through so many legal battles. He's still going through legal battles in order sure that he can control and have a say for his wife. But you don't want to have to deal with that. Even in your healthcare directives, you can be as specific as possible. So, for instance, if something happens to you and one doctor says, she's not gonna make it, she's gonna be a vegetable, you know, you want her to stay like this forever until she dies, she can, but I recommend you just take her off life support, whatever it is. You can denote in your medical healthcare advanced directive that you want 2 doctors to sign off on this. You can be as specific as you want to. You can say, I want 2 doctors to give the same prognosis that I'm gonna die either way, I'm not gonna improve. You can denote that in your proxy. And you can even say, I want my doctor, specifically list your doctor's name to sign off on this prognosis. Before you make a decision, you can say, take me off the machine right away, or leave me on for a month. If no change, then take me off. So you can be as specific as you want to when these things happen. And it doesn't matter how young you are, how old you are, it's important to have these in place. Yes.
What if somebody like me who, I'm young, and I ain't got nothing going except school and life, I ain't got no wife, I ain't no children, I ain't got nothing to eat. So, looking at, of course, you probably wouldn't advise me thinking like, oh, like my parents, my mom, or my sisters. So, you know what I'm saying, probably get it. I know it should be somebody younger than you.
No, not necessarily. It doesn't have to be anybody younger than you. It could be somebody that's the same age. It could be your mom, it could be your sister, it could be a
I
aunt.
put my mom automatically.
Yeah. Yeah. But like I said, even if, you know, your mom is gonna be your automatic, you can still denote and be as specific as possible. Say, get 2 doctors, I want 2 doctors' opinions to say the same thing. You can say, you know, leave me on the life support for 2 months or 1 month, then take me off. You can be as specific as possible because you're making the decisions now for how things are gonna happen when you can't make those.
So what if I do get wife, me right now, I ain't got wife.
Then you update it.
My wife on, oh, you
You update, that's important, that's a good question, and good point that you bring up. You always wanna make sure these documents are up to date. There's another example I can't think of right now, but I think it was James Brown, yes. So, James Brown died in like 2006, and he had a trust, and in his trust, he left all his stuff to like a scholarship fund for these kids and all this, but this was done before he got married to his like last life and had a kid. And he had a will as well. Actually, it was one other way, I can't remember now. It was a will before or the trust after. Either way, they contested it because his wife came after one of the documents was created. So they tried to contest it and say, well, I should have gotten, you know, this should have been changed, whatever. And they finally settled it today after several years. But that's why it's important to keep these documents up to date. So things may change, you know, somebody may get sick, it might be, you might not trust them, you know, whatever the case is. And you change that up there if you want to. Next thing, financial power of attorney. It's important to have this document completed. So you have a template of this document in your folder as well. It's called durable power of attorney. So again, if you get incapacitated in some way, you're unconscious, you're sick, you're in an accident, whatever, something happens. You want your bills to still be paid, right? You want your mortgage to still be maintained. You want to, you know, make sure your car note's paid, your cell phone, all these things, your insurance policies. You want to make sure everything can run smoothly still, as if you were still living, or still, you're still living, but as if you were still able to do those things yourself and not incapacitated. So, you want to complete a financial power of attorney. This allows whoever you set as the designated agent, that basically an agent for you. This allows them to, you know, use your bank accounts to write checks or pay your mortgage or your bills. This allows them access to your finances to do those things. So it's important to have that. Also, that document I put that in there so that you can just fill out the blank spaces and have it notarized, and then you'll have that document. Okay. So I encourage each of you to do those as soon as possible. So who do you give a copy to? Dual power of attorney. The dual power of attorney, I think you just keep that. I think you just keep that in case you need it. So like if like I get sick or something and I'm in the hospital, then you have that document, and you just go to my bank, you would just take it there, say, okay, and then they, you know, no problem.
The advanced, healthcare directive and the power of attorney documents that you hold up to. Both of those should be witnessed by two people and notarized. And the notary is, witnessing your signature, whoever the owner of that document is. But they're also witnessing they're witnessing a couple of things. Number one, the person these documents belong to, they're witnessing that that person is still competent. They're not in dementia or mentally not able to make that decision. A notary cannot notarize those documents if you are not able to make decisions for yourself. So you have to be living and able to make those decisions in order for the notary to notarize those documents.
I think that's the hard part of confusing the start, because it seems like it's a lot of steps that could block you, like you think you did right, and then you go all the way to the, place we supposed to take you to notarize, and they're like, hey, you don't got no witness, so hey, you don't have no witness, so we're gonna turn it back to you.
No, but even still, so like, Tony and I were at a bank one day, and so there was a company filling out some documents, and the banker called us over and was like, hey, can y'all witness them signing this document?
Always like-
We didn't even know those people.
We didn't know that.
But we just went over there.
We just witnessed that they were signing
You don't think somebody
the
can stand
document.
on
No,
you?
they showed us their ID, we witnessed them signing it, and we signed off that they signed it, and that was that. So that's not a big deal, you know, that's not a problem that you should worry about. So, again, the healthcare, director, you do wanna make sure you give that, copy of that to your doctor, your primary care physician, so that they'll have that on file too. But you wanna keep the originals of these documents. So, teacher report, we're almost done, I know it's a lot of information.
Can you go back one more time?
Yes.
Power of attorney real fast. And actually, I deal with this more than anything. When the principal, the person who created the power of attorney, when they pass away, that document is no longer good. So the power of attorney dies when the principal dies. That's when you go into having a will and and your trust. That's when those things come into effect. But as long as you are alive, that power of attorney is alive. When you die, it dies.
Yeah, and you wanna make sure it's somebody that you trust, because, you know, while you're living, they actually have, you know, the power to act as you. But you wanna make sure they don't use that when they need it, when you're incapacitated. So, good point. So, one of the license here, is called beneficiary designations. So, if you have a life insurance policy, and, you have the beneficiaries set on there, then you can skip all of that. You already have the beneficiary set as, you know, mom, sister, dad, kid, whatever. Then you can skip over the will process. This is fast track. Your 401k is as a beneficiary, has a beneficiary listed, all that stuff. So, your will does not control that, but you can put this in your trust. So, I'll say, it's good to go ahead and transfer. And it really depends on how you want it to be done. So, for instance, I have like several accounts that I know will be passed over, and I already had, before I got my trust done, I already had my beneficiaries listed. But since I have so many, when I created my trust, I wanted to, within my trust, I listed the beneficiaries and what percentage of my entire estate that I want them to have. So instead of just, let's say I have $20,000 life insurance policy, instead of just giving that $20,000 as to one person as a beneficiary, and then they have to take out the funeral costs and all that. I don't have to worry, don't have to worry about that. If people have, oh, they got more than this, they got this one. No, put everything in the bucket. This life insurance policy going in the bucket. Another life insurance policy going in the bucket. Take the beneficiary name off of there. Put the beneficiary name as my trust. Then that life insurance policy will be paid into the trust when I die. That 401k, since I changed the name from my beneficiary to the trust, will be paid into the bucket. So everything will be in the bucket, it'll be a big bucket, and then the beneficiaries can get their percentage, their distribution from the entire bucket. And it's not just like, oh, you get what's left over after, you know, this, funeral costs are paid from this one policy. No, it's in the bucket. After everything is done, then you get your portion. So, but you can't skip all this fast track by just listing your person, your loved one as the beneficiary, on these accounts. So, we're here today because we want to cultivate generational wealth. We want to make sure we don't don't just leave this information with us, that we can make sure that the people behind us, generations to come, have this information as well. Because passing out money without passing out financial literacy is just a slow way to go broke. So usually, wealth drops off at third generation because they're given the branches, but they don't have the roots. They don't have the values, the literacy on how to plan, how to make sure that everything is in place and managed properly so that their family can have something going. So, this is why we're here. And final act of grace, we won't talk about we won't talk too much about this because our time is almost up. But one thing you can do for your family before you die is plan your funeral. Plan for your funeral. And it doesn't have to be specific or long drawn out. You don't have to like write out the whole program or the obituary, but you can decide in your documents, I want this funeral home to be chosen. I want to be cremated, or I want to have a private funeral, or I want to have a funeral, a graveside funeral, whatever. You can list it if you want somebody to sing, whatever. You can list all that stuff. Plan your funeral ahead of time, because when your family is dealing with your death, they are so stressed, they're grieving, and they really can't think properly, and they have to make all these decisions like this on the go.
Yeah.
And sometimes they're not gonna make the best decision or the decision that you would have made when you were living. So you plan ahead and say, this is what I want done. Take me to this funeral home. I've already talked to these people. I know these people. They're gonna do, right, do justice. This is how much you can even pay. Make a payment plan for your funeral costs, so your family won't have to worry about that. You can buy a cemetery plot beforehand. So if you have the ability to do that, I recommend that. But if you don't, just at least say, this is the basics. Take me to this funeral home, cremate me, have a private funeral, just whatever. Those basic things, you can set those up. Yes,
With
ma'am.
that, when I was selling, insurance, they basically tell you to do that. And they give you the paperwork to do your, go ahead and set your funeral up.
Yeah.
Cause that's kinda like a funeral, the obituary, they give you everything, the paperwork you provide us with.
Yeah.
Because that is so stressful, because we just went through that.
Yeah.
And they just tell you, they really advise you, hey,
Yeah.
pre-plan this is the paperwork you can fill out, if you
Exactly.
want, whatever,
Exactly.
what preacher you want,
Mhm.
it's specific
Right.
like
Who
that.
want the preacher eulogy? Who
kept one
don't
on
want the
page.
preacher eulogy?
They
Oh.
had all of that. I was shocked when I saw preacher.
So, yeah, so those are good things. So basically, the ecosystem, your ecosystem of peace, it includes your bucket of the trust, that's the centerpiece. Remember the trust, that's your bucket, you gotta put everything in there. Then your pour over wheel, which takes up, takes care of everything you didn't put in there, like your backup. Then your living documents, in case you get incapacitated in some kind of way. Your POA, power of attorney, your advanced health care directive, all those. And then your beneficiary designations if you don't decide to put everything in your bucket for your trust. And lastly, the proactive funeral planning. I advise it, I recommend it. People, my family always says, why are you talking about that? Why do you want to write your obituary? Because I know that it's gonna be important, I don't want you to have to worry about that when I'm gone. So, pass down peace instead of problems. Okay? Peace instead of problems, yes. So these are some things you can do, 3 things you can do today. Audit your accounts, check your beneficiary designations. So, do you have a designated beneficiary for your accounts, your 401k, your bank account? On your bank account, you can list a payable on that, a POD, you can list that. You can list a beneficiary, you can have joint owners, there are different ways you can do that so that your family won't have to worry about having access to your bank account when you're gone.
Before that happened with us, I never knew that, because when you're opening up accounts, I've opened up accounts at numerous banks. Open up account, nobody never said nothing
Yeah.
about a
You
payable of
never
that.
came to your list.
Wells Fargo,
Yeah.
America's First, Credit Union, Regions, nobody never said that.
It doesn't matter how young or old you are, have a joint owner or a payable on
Look,
death, individual
I'm
on
44,
death.
I never
Please
heard about
remember
payable
that.
of
Yes.
death until
Yes.
this year was the first time I ever heard of
Yeah,
payable
yeah,
of death.
yeah, and we don't wanna on different stuff. So this is how I found my lawyer, my attorney for estate planning, through my job. You know, they offer like 25% off on certain, and you choose certain lawyers. It was still expensive, but the 25% off helped. So, check out your EAP, discount services with your job. And if you need a lawyer, and it's more complex where you can't just type in online or fill in the documents, check that as an option for you to get your, estate planning done. And then lastly, start the process. You have 2 documents here you can fill out already. The POA, the Advanced Healthcare Directive, you can fill those out today, go get them notarized, and have that on file for yourself. So start the process, whatever you have that's straightforward, go ahead and put it in a trust. And then if it's more complex, then seek out an attorney for that. So, again, we don't wanna just solve problems when they happen, cause you can't do it, you're gonna be gone anyway. When they happen, you're gonna be gone, or you're gonna be incapacitated. So, let's plan ahead. We wanna position ourselves to prevent them entirely. So, let's step out of the fall and design your destiny today. So, any questions? Yes, ma'am.
So my question is, if, just say for instance, you have a home that you're still paying on, but you wanted to put into a living trust. I know you fill out the quick claim deed, you put the, home in the trust name. How, does that change anything as far as, because you gotta look, the individual is still paying on the mortgage.
Yes.
Do you have to change anything from that aspect, or that stays the same, and the ownership is the only thing that's changed?
Yeah, you don't have to change it with your bank, with whoever you, are lending with. You don't have to change it, but you can change it. So you can reach out to your bank and say, hey, you know, my house is no longer in my name, it's in the name of, my trust. You can do that, but you don't have to, that's not necessary. You can just keep paying on it until, you know.
Gotcha.
Yeah.
Okay.
And then, let me add to that, as Terica said, you don't have to, and I recommend you don't, because it's due, they can change the terms of the mortgage.
Right, okay,
Because they're gonna have to underwrite again.
right,
So that's why
Okay.
they don't, because your interest rate and all that stuff can change.
right, okay.
Oh, that's good.
Any other questions?
You gotta take a picture of all 3 out, and tell them black women.
Yes. Yes, we can, and no more questions, and I wanna take this time out to thank our speakers, our lovely speakers, who are just full of information and everything that we needed today to plan for our futures. So let's thank Ms. Ashley Brazil, Phil Walker, and I wanted to thank you all. Thank you for being here. Thank you for taking an interest, an active interest in your future and your family's future, and planning ahead and not waiting till problems come. So let's make sure we pass